My name is Vandana Jain. I'm dealing with the topic confidentiality under competition law. So, confidentiality is one of the important aspects that the law has to be taken care of because disclosing a confidential information to the competitor, which will cause an adverse effect or a serious effect on the disclosing company. So, it has to be taken care of. So, the earlier the MRTP Act 1969, Section 60 deals with the confidentiality and it give due significance to that concept, but now it is the concept of confidentiality is deals under competition law 2002 and the competition commission of India regulations 2009. So the first is section 57 of the competition law 2002, and the section 57 says that information of any enterprise that is obtained by the competition commission or the appellate tribunal shall not be disclosed without the prior permission of the enterprise in writing, otherwise than in compliance with the provisions of Competition Act or any other law in existence. So Section 57 gives a due protection to the company or the enterprise that their information that is obtained by the Competition Commission or the appellate tribunal shall not be disclosed on any circumstances unless they give permission in writing to the authority. But Regulation 35 of the General Regulations Act, General Regulations 2009 narrows the scope of the Section 57, and it clarifies that only in certain cases the confidential information can be protected. That is, the public disclosure which would result in the disclosure of a trade secrets, or which results in the destruction or appreciable diminution of commercial value of the information, or the disclosure reasonably be expected to cause serious injury on the disclosing and on the entity. On these circumstances, the authority should not disclose the information. And this regulation 35 narrows the scope of section 57. And the General Regulations 2009 also deals with certain factors that the Competition Commission or the Director General has to be taken care of while deciding a information has to be protected or not. So the factors are the extent to which the information is known to the public, and the extent to which the information is known to the employees, suppliers, distributors, or other parties involved in the party's business, or the measures taken by the party to guard the secrecy of the information, and also the ease or difficulty with which the information may be acquired or duplicated by the others. So these four factors has to be taken care of by the appropriate authority, that is the Competition Commission or the Director General, while taking care of the while deciding the request of confidentiality. So Section 57 is the mandate provision providing the protection to the confidentiality and strengthen the protection of the documents as well as the informant as well as the identity of the informant. So why this such a provision has to be incorporated under law? That is the purpose for which the confidentiality clause is incorporated. So the first purpose is that protection of the trade secrets. That is, the Act tries to preserve the commercial secrecy, as such information, if comes to the knowledge of the competitor, it may injure the interest of the entity which is concerned. So in a case PUBL versus Competition Commission of India, the major issue was that there was a breach of confidentiality in relation to the confidential information obtained by the commission. So here the Delhi High Court held that it is the duty of the Director General and the employees of the Competition Commission has to protect the confidential information. So they have to take adequate measures for the protection. So the next purpose for this clause is that the protection of identity of the informant. That is, the provision not only protect the documents but also protect the identity of the informant. That is deals under Regulation 35 of the regulations, Competition Commission of India Regulations 2009, and this is to not to put the informant in a position of disadvantage, and it is also ensures that the fundamental right of privacy to the person, which is guaranteed under Article 21. But in certain situations, that is, the DG can disclose the documents and the evidence furnished by the enterprise if he deems fit, and if he disclosing such information, he has to take a prior approval from the Competition Commission, and has to also record the reasons as to why the disclosure is necessary. So the next or the last purpose of this confidentiality clause is that the reputation loss, that is, the loss of reputation and a consequent exposure to the civil suit against the enterprise is another reason so as to the incorporation of this clause, because it could the disclosure of the confidential information could expose the financial position of the company or the existence of a defective product, which may affect the image of the company. So next is about the procedure to acquire the confidentiality. So the first procedure is that the parties who needed the confidential protection of confidentiality has to uh, apply further, or has to apply to the Competition Commission of India for the confidentiality, and they can claim for both the documents as well as the identity of the informant. And after providing reasons to exclude the information from the public disclosure, the CCA under the Regulation 35 can order for the uh, protection of the confidentiality to the parties. And while deciding such confidentiality, the CCA or the Director General has to satisfy itself that the information obtained is so commercial in nature, and it is so sensitive, and yeah, any kind of disclosure of such information would harm the enterprise. And if such order under Regulation 35 is granted, then the CCA and the DG has to require to maintain the privacy and the confidentiality strictly, and while conducting investigation and proceedings as provided under Regulation 35 and the proviso of Regulation 20 Clause 4. And then when the document is granted, the confidential treatment has to be given segregated from the public record, and it has to be secured bearing the title that the confidential record under Regulation 35, and also the date on which the confidential treatment expires has also to be mentioned. So next is about the conditions waiving confidentiality of claims, that is, the conditions at which the confidential information can be disclosed. That is, in the Section 57 of the Competition Act 2002 itself speaks about two grounds at which the confidentiality of the information can be removed. That is, the first is waiving of the rights itself by the enterprise, and for the purpose of the Competition Act 2002, and for any other law of time for the time being in force. Then on these two grounds, the confidential information can be removed from its protection. So the next is about the disclosure of the identity of the informant. That is, Regulation 6A, proviso to Regulation 6A of the Competition Commission of India, Regulation 2009, deals with certain conditions at which the identity of the informant can be disclosed. That is, the conditions are: if the disclosure of the identity of that particular person is mandate under law, or the applicant himself voluntarily consented for the disclosure in writing, or the applicant itself discloses the identity in publicly. So in these conditions, the identity of the informant has not to be protected, or does not need to be protected under the Act. So next is about the grounds for taking away the privacy of an enterprise during the proceedings. The Regulation 47 of the Regulations 2009 uh, speaks about the commissions, speaks about the proceedings that has to be taken care of before, that is conducted before the commission. That is, the proceedings of an enterprise before a commission has to be protected and not to be open to the public. But the commission can otherwise order otherwise, that is, can open to that proceedings before the public, and on such uh, uh, disclosure, the commission has to record the reasons as to why such disclosure is done. And while determining on that matter, the Commission has to take care of four factors. That is, the Commission has to ensure that the disclosure of such proceedings or the information of an enterprise is not harm to the party owing to the disclosure, or the level of encouragement in publishing the information, or it has to be seen that whether such disclosure is needed for the efficient and smooth conducting of or the functioning of the proceedings. And finally, the Commission has to consider the resources also. So the next is about the Rule 7 Clause 3 of the Customs Tariffs Rules 1995. And such rules, Rule 7 Clause 3 says that if the designated authority came to the conclusion that the information does not need any protection under the Act, then he can disregard that information. So these are the various exceptions under the confidentiality concept. And in a case Sterile Industries India Limited versus Designated Authority, the court held that whether an information warrants confidentiality or not is decided by the designated authority, and it depends upon the case-to-case basis. That is, there is no fixed principle or rule as to whether that is a particular information has to be protected or not. So the next is about the liability for the non-compliance of the confidentiality. That is, it is the duty of the Competition Commission or the Director General that they have to protect the confidential informations of the enterprise and the identity of the informant. In case of a negligence leading to the failure to maintain such confidentiality, then they have to pay compensation to the enterprise which is in concern. And according to Regulation 9 of the Competition Commission regulations, if it says that any breach of agreement or on or behalf of the any enterprise or professional engaged in the proceedings to sign an agreement containing a clause of secrecy, then such breach shall be considered as a sufficient ground for the termination of the engagement made under the contract, and such professional or the expert debarred from such position. This is the major concepts regarding the confidentiality. And in the recent period, the CCA has taken a liberal approach in granting the confidentiality requests of the parties, and the Competition Commission ensures and give due respect to the commercially sensitive informations, and it gives protection to the confidential informations upon the requests of the parties. That's all regarding my topic. Thank you.